Section 1500, control of the work. This section, I think it's an interesting sort of circular positioning by MnDOT that basically gives the engineer significant amount of authority to make decisions, but then at the same time it says, but although it's might be a final word with respect to the contractor, it's not the final word with respect to MnDOT. So according to the language of the new section 1500, MnDOT can override the engineer at some later time, assuming at some later time MnDOT agrees with the engineer. And the other one is MnDOT nevertheless is going to, so they're going to try to pursue you from every angle. 1502, I know that MnDOT, the red flag, MnDOT has required this on particular project, though I think it was tended to be in the supplemental specifications rather than the standard specs, is the contractor's progress schedule has to define the events in such a manner that nothing lasts for longer than, actually that's a different point, longer than 20 days. This point is that you got to give the engineer 14 days to review submittals. But the concern here is I'm aware of one project where MnDOT's engineer would take the 14 days and within that 14 days make one small change. One small change that wasn't even necessarily a defect in the submission, but they decided they wanted something slightly changed. And every time the resubmittal was done, MnDOT would restart the 14-day clock. And they did this multiple times. So in the course of the project, this added on to significant delay for the contractor, and it was a design-build contract. And MnDOT's response is, well, this occurred over the winter months. You can't be out in the field anyway, so what difference did it make? Basically ignoring the fact that during the winter months you can still be doing design and manufacturing. And so essentially then when the notice to proceed was issued in the spring, sometime during April, they were already a couple months behind because they didn't have what they needed to have manufactured for this particular project. So the practice point is to the extent be aggressive, you can be aggressive with the engineer and get on them right away to not let them do that. Again, 1504, the engineer decides all issues concerning a discrepancy or defect with subject, again, to MnDOT's override. 1505, the big red flag here is the language that says the contractor, you have a certain level of responsibility for interference of other contractors. And this would violate the anti-indemnity law, which makes you only liable for your own negligence. You cannot be negligent for the acts of other contractors over whom you don't have responsibility or control. So it begs the question of whether this provision would even be enforceable, but to the extent it violates the anti-indemnity law, it suggests that this would be rulemaking, this provision by itself would be. When we were looking at the initial, this is under section 1503, the one at the bottom, when we were looking at the initial draft, MnDOT had added new language to not only say that the contractor has to provide materials and work within the tolerance range, but basically added that it's not only has to be within the tolerance range, it's got to be in the middle of the tolerance range. And MnDOT, when we asked, well, that's not the appropriate use of a tolerance. The tolerance is the range, of permissible, that's permitted for that particular item of work, and it's not intended to be to provide the range that you have to be in the middle in. It's supposed to be the accepted range. That's the meaning of a tolerance. MnDOT disregarded the industry's objection, stating that, well, the purpose of a tolerance is to accommodate occasional minor variations, essentially restricting the use of a tolerance. And MnDOT also said, well, it essentially allowing it the subjective ability to be able to determine when it thinks that essentially the tolerance is being overused. I'm not going to go through every provision, but I do want to highlight a couple of red flags. MnDOT has added a provision that says the superintendent now has to have the authority, well, it says or a designated other, if there is such a designated other on the project, that they have to act. They're the ones that have to have authority to sign supplemental agreements. And so basically, I suppose that requires more burden on you to make sure the superintendent acts with actual authority. On utilities and properties, MnDOT has increased the contractor's responsibility. The one thing that we were able to add was for MnDOT to at least include language requiring it to specify the affected utilities in the contract, because if the contractor is responsible for providing adequate notice of the work that would be needed, that could potentially impact a utility, it seemed only fair for MnDOT to have to tell you what those utilities might be. 1512.1, unacceptable work. The big red flag here is it's not unfair that MnDOT requires the contractor to come back and do it, but it's got some language to say or require the surety to do it. And the red flag there is, well, there are particular requirements under a performance bond, and it's not simply because MnDOT deems that the surety should do it. It's got to follow those requirements. Now, one could argue maybe those are implied as some of the language that as MnDOT has used in some of its explanations for why it refused to change some provisions, but the language on its face says, well, if you don't do it, it's going to require your surety to do it, without necessarily including any language that MnDOT has to require the procedures in a performance bond. Unauthorized work is any work performed without a supplemental agreement or contrary to the engineer's direction. So you always want to pull it back to what the contract requires. So if you think the engineer's direction conflicts with the contract, you better make sure to make that claim or put in the notice, that written notice under 1402 initially, and then go on to the claims section, because MnDOT says you've got to exhaust one before you can pursue the other. Although the engineer is given a substantial amount of authority under these standard specifications, as it indicated, MnDOT necessarily has final say over the engineer. So don't necessarily rely on what the engineer says if you disagree with his interpretation of the contract. 1512.3, this is another area where MnDOT is trying to reach further into your level of responsibility, is not only now can they withhold payments from you on this particular project, they've now added language that says that they can also withhold payments from any other contract with MnDOT. We pointed out that this would likely cause a problem with sureties, and I don't know if there's any sureties out here, but we know the sureties we've heard from think this is a huge problem because they don't bond for the contractor generally, they bond project to project, though obviously each project impacts on the particular underwriting. But MnDOT had said, yeah, you're right, but we want it anyway. We think it's in the public interest, so we're going to keep it in. 1513, a new requirement to submit a proposal and load analysis certified by a professional engineer to MnDOT's engineer for review. It puts the contractor responsible for this, and we figured this was basically probably arose from 35W. But it does kind of beg the question, is then if the 35W is truly the impetus for this section, which we think is probably reasonable, is then the engineer responsible for knowing if there was a design flaw? As you probably are already aware, the ultimate issue on the collapse of the 35W bridge came down to the size of the gusset plates. So in that particular case, even if the contractor that was on the bridge at that time had performed this analysis, it's highly unlikely that that would have created any different result in that particular circumstance, because it's highly likely that that engineer was not going to go and reevaluate the design of the bridge to, on its own, determine that the gusset plates were undersized, as was the eventual determination. But if the contractor is responsible for basically making those calculations on whether the loads are allowed by that bridge, would MnDOT then say, well, if that responsibility carries beyond just the standard review, and you'll become basically, you have to buy off on the design? I think there would be good arguments that you don't, but the language here certainly doesn't create any exceptions for such a thing. 1517, claims for compensation adjustment. This is another section of major change. Now, probably the biggest issue here is that the contractor has to exhaust the requirements of 1402 and 1403 before making a claim. Under 1517, there is no particular expression of what it means to exhaust the requirements. And on its face, one would say, well, you went through the 5 days, the 10 days, the 20 days, and then the 5 days. But we're thinking as a practice point, make the claim within 5 days of receiving any decision from the engineer under 1402 and 1403, or ask at the same time as you make that second notice, or that first written notice, second actual notice, is ask the engineer to define, well, when will this be exhausted? Because if you only have until, or if you have to exhaust, it begs the question of whether MnDOT could argue, well, your claim was premature, so even though it might have been timely if it was premature, you certainly wouldn't want MnDOT to say, well, you still didn't follow the procedures and therefore you've waived your claim. 1517, I won't go again through all of these in detail, but it says a notification of intent to file a claim, but it doesn't actually say file the claim itself. I think it's probably reasonable to determine this is your claim, even though the language itself is somewhat unclear. MnDOT is also requiring when you submit the claim, now you've got to separate out the quantum of the claim from, or rather whether you get the claim from the quantum of the claim and the time impact into separate analyses, though it does beg the question of whether that is reasonable under most circumstances. Basically, it places more burdens on the contractor to do a more detailed review following its particular requirements, and there's a lot of reference to the scheduling requirements of Section 1806 that need to be followed. The required certification of claims, I think that was already in at least it was in the supplemental specs, if not the standard specs. We were somewhat successful to try to minimize potential False Claims Act allegations, to delete or to change the certification so that it's not an absolute statement, but to the best of your knowledge. So hopefully at least that would be a defense, that if you weren't aware, this would probably have greater application for if you're doing a pass-through claim on a subcontractor, that at least if you don't know or have good reason to know of the subcontractor submitting something that may or may not be fully claimable, that hopefully this would be sufficient protection for you if you didn't have reason to know. Because the big burden would be if both of you would be tagged with having submitted a false claim. Another exhaustant language, again not defined, under 1517, the claim review or the claim process review by the engineer has to be exhausted before litigation is commenced. So sort of the overall view of Section 1500, MnDOT's putting risk on you, taking away risk from itself, and follow the path that it sets forth and make sure you know all those times that it's requiring.